Well, good afternoon, everyone. Welcome to our bi-monthly webinar. This month, Erin and I will be talking with you about what employers need to know about pay equity audits. This is an area that I think if you don't know already, you'll discover through the course of our time together today, is a rapidly expanding area. I think every time we talk about it internally, there's at least one or two new laws to talk about on this topic. And so we're excited to share with you all the many facets of this issue today and help you get a better sense of what the rapidly evolving legal developments are. But let me first start by telling you who we are. Erin, thank you. So I'm Bryan Starrett. I'm a labor and employment attorney at Brooks Pierce here in our Greensboro office. And with me today is my friend and colleague, Erin Barker, also part of our labor and employment team, resident in our Raleigh office. We're excited to have you with us today. Next slide, please. So a couple of just housekeeping items. First, let me give you an outline of where we're headed and what we're going to talk about. What does pay equity really mean here? And what are the topics that really relate to this overall issue? We're going to start by really a reminder, sort of a level setting of employee rights under the National Labor Relations Act. And I think once we do that, you'll see that is sort of a law that sits in the background of all of the issues we're going to talk about today and informs the way that we think about these issues regularly. We'll talk about an overview of what does pay equity mean? What are the laws that govern pay equity? What are the specific issues that might relate to federal contractors on pay equity? And then related to pay topics generally, we're going to talk about salary history bands, which some of you may be familiar with, pay transparency laws, and then finally pay equity audits, which is really if you needed to get a better understanding of whether you have potential pay equity issues, how would one go about doing that? So this is our roadmap for our time together today. Next slide, please. So just as a reminder, this is a very rapidly evolving area of the law. And so we're going to do our best to give you a general overview with general information, but would ask that nothing that we share with you today should be considered legal advice or really used as a substitute for consulting an attorney for legal advice regarding any particular circumstances that you are navigating. Also, and I really can't emphasize this enough, there's lots of legislation pending on some of the topics that we're going to cover today, both at the state level and even at the municipal or city or county level. And so much of what we're going to talk about today, while there's a lot to cover, may be outdated very soon because new laws will come on the books. So just please be aware of that. All right, so like I said, where we're going to start is level setting of employee rights under the National Labor Relations Act, or the NLRA. So let's just, as a reminder, you might think that the NLRA, well, that's labor relations. That's a law that applies to unions or to employers that have bargaining units or union employees, and that's actually not right. The National Labor Relations Act applies in a very broad sense, and because it talks about employees' rights as they relate to their, quote, terms and conditions of employment. And what could be a more fundamental term or condition of employment than what an employee's pay is? And so the NLRA prohibits employers from restricting their employees in communicating about the terms and conditions of their employment. So, for example, it is unlawful for an employer to punish an employee or retaliate against an employee for discussing his or her wages. That's talking about a term or condition of employment with another employee. So you can't have a policy that says employees are forbidden from talking about their employment. Nor can you have a work rule or a policy or a hiring agreement that prevents employees from talking about their wages with each other, or that requires them to get some sort of permission before doing that. That is another type of rule that would infringe on an employee's right to discuss the terms and conditions of their employment, because under the NLRA, that is what is called a protected concerted activity. Employees acting in concert together. They don't have to be a union to enjoy that protection. They just have to be employees. Let's go to the next slide. So now we're going to turn to Erin talking about an overview of pay equity. Erin.
All right, thanks, Bryan, and thanks everyone for joining us. As Bryan said, I'm Erin Barker. I practice in the Raleigh office, and I'm going to take us on a little exploration of an overview of pay equity, what it is, and sort of all of the laws that are developing under the umbrella of pay equity. So pay equity, in essence, is providing the same compensation to employees who perform the same or similar job duties, regardless of gender, race, or other protected characteristics, while also taking into account other factors like experience level, tenure, job performance. It's not saying we're going to have an employee who's been here for 1 year, an employee who's been here for 20 years, and make sure they have the same pay just because of one of these characteristics. So it does take into consideration other factors. And especially in the wake of the Me Too movement, the landscape around pay equity has been evolving very rapidly. As Bryan said, there's often new laws being introduced, passed at the state level, at the local level. There are laws that get introduced at the federal level as well. And legislators are passing these laws sort of after determining that what we currently have in place, all the laws that are currently surrounding pay equity, either haven't done enough or have too many loopholes or don't have sort of adequate remedies. And so they're finding that pay gaps and discriminatory pay practices haven't really been resolved. There's also been a noticeable uptick in the last few years in litigation surrounding discriminatory pay practices. People are alleging that companies are not paying equally, and so we're seeing an increase in litigation. So the next question is, what laws currently apply? So we know there's all these laws coming in, but there have been laws in place that address pay equity. A couple of the federal laws applicable to sex-based compensation discrimination include the Equal Pay Act and Title VII. In addition, Title VII, the ADEA, and the ADA also prohibit discrimination, not just on the basis of sex, but also race, color, religion, national origin, age, disability. And that's just at the federal level. So many states and local governments have expanded pay equity requirements and sort of broadened all the requirements in place. And so we're going to look a little closer at some of these laws next. So next we have the Equal Pay Act of 1963. So this has been around for almost 60 years. And it requires employers to give men and women in the same workplace equal pay for equal work. And this covers all forms of pay. This covers salary, overtime, bonuses, stock options and incentive plans, life insurance, vacation and holiday pay, hotel accommodations, reimbursements for travel expenses. This covers any form of compensation. And equal pay for equal work doesn't mean identical work. It means substantially equal. So we take a look at the skill required, the effort required, the responsibility required for this position, and the working conditions. There is an affirmative defense for employers if there are pay differentials. So if you look at your pay practices and you say, oh, well, this person gets paid more than this person, and I'm worried that, because one's a man and one's a woman, that could be seen as discriminatory. There are factors such as seniority, merit, quantity or quality of production, and then factors other than sex that can influence pay differentials. Be careful with the factors other than sex, though. It's not clearly defined. It's kind of murky. It's changing what counts as a legitimate factor other than sex. It could include things like education, certifications, training, shift differences. So, someone could get paid more if they work a night shift versus a day shift. Geography, someone in a metropolitan area like New York might get paid more than someone in a less metropolitan area, or even just in a different state that has overall lower costs of living. In some cases, courts have found a factor other than sex could include prior salary history. Other courts have found that it can't. And that's especially something to keep in mind as we're going to be talking about salary history bands later in this presentation. If you hire somebody and you ask for their salary history and that results in them getting higher pay at their new job, you have to consider whether you're allowed to look at their prior salary history under various laws that we'll take a look at. All right, next we have Title VII of the Civil Rights Act of 1964. We have the Age Discrimination and Employment Act of 1967 and the Americans with Disabilities Act of 1990 as amended. These laws expand beyond just sex and prohibit compensation discrimination on the basis of race, color, religion, sex, national origin, age, or disability. Under these laws, there's no substantially equal requirement about the job. So it's a bit broader of a protection there. And compensation discrimination under these laws can take many forms. It's not just a difference in pay. It can be difference in opportunities for promotion. So it could be that somebody has a barrier to equal access to higher paying jobs. It could be seemingly fair compensation policies or practices that have a disparate impact. Like it might seem fair to have a bonus option for heads of households, but in certain cases that's been found to have a disparate impact on women. And under these laws, we do see real consequences for employee violations. So I'm going to go through a couple examples of some lawsuits over the last couple of years that resulted in employers having to pay damages for violating these laws. So first, we have a 2020 EEOC lawsuit. We had a nursing home in Kansas City. 12 nurses were paid less, or 12 female nurses were paid less than their male coworkers. They performed the same job. The court found that the nursing home violated the Equal Pay Act and Title VII of the Civil Rights Act, and the nursing home had to pay $40,000 in damages to those 12 employees. Another example, 2021, so just last year, there was a consumer loan and finance company. They were paying female branch managers lower salaries than male branch managers, even though it was, the same job, same responsibilities, same circumstances. They ended up paying $100,000 to settle. And then, the EEOC publishes that settlement information. One more example, we had a hotel management firm just last year in 2021. They had to pay $400,000 and had extensive non-monetary relief to settle a discrimination lawsuit. The facts of this one were this hotel management firm was paying a male guest service rep $15.25 an hour. There were several female guest service reps who were being paid $11 or less per hour. There were some other violations. When the hotel management firm realized this or, received complaints about this, instead of increasing the pay of their female guest service reps, they decreased the pay of the male guest service rep to try to make it equal. But the EEOC said, no, you can't do that. You now have to pay damages to the female employees and the male employees whose pay was reduced. So just as a reminder, if you are looking at your pay practices as an employer, and if you are thinking, oh gosh, there are some inequities here, the solution is not to reduce the wages of men to equalize pay. So federal law prohibits employers from reducing the wages of either sex to equalize the pay. So that was just the federal laws. Many states have expanded pay equity coverage beyond gender and sex to include race and other protected characteristics. Many of these laws are broader than federal laws because they don't require substantially equal work. They use terms like substantially similar or comparable. For North Carolina employers, just a note that North Carolina does not yet have a comprehensive state equal pay law, but North Carolina does have the North Carolina Equal Employment Practices Act, or the NCEEPA. This applies to private employers with 15 or more employees, and it prohibits general discrimination based on race, religion, color, national origin, age, sex, or disability. So most pay practices that are unequal or that are discriminatory would be covered under that, but it's sort of a more general law, not a specific pay equity law. Next, we're going to take a look at some special considerations for federal contractors.
Thanks, Erin. And everyone, please forgive me. I should have said at the top, if you have questions, please feel free to put them in the chat and we will be sure to address them probably at the end of the program, but please do note them as you have them because we want to make sure we get those questions answered. So turning now to federal contractors. So I'm not sure if any of you work for or have ever worked for federal contractors, but if you do or you have, you undoubtedly know that there are some heightened requirements for federal contractor employers, specifically as they relate to affirmative action programs and issues related to those programs. Among them is pay equity audits, which really means requiring an employer to dig in deeply and understand what their pay practices are as across both positions and demographics to try to ensure that there are no discrepancies within that employer. In fact, and this is a very recent development, just last week, the OFCCP, the Office of Federal Contract Compliance Programs, issued a new directive on this exact issue of pay equity audits. These are audits that a federal contractor employer is required to do. They have to perform in-depth self-audits of their employment processes, including all of their compensation systems across certain demographics. You do that self-audit, and then the recent directive that came down is really about giving more direction about the specific requirements of those audits that, again, must be done annually, and address the extent to which perhaps issues like attorney-client privilege can and perhaps may not be appropriate when you are asked by the OFCCP to produce the results of your self-audit, because this is not something you submit, it's something that you have to have available if you are subjected to an overall compliance audit by OFCCP. One of the things that you would need to be able and ready to produce as a federal contractor would be your annual self-audit. So specific issues there. Let's turn now to salary history bands. What are these? Well, if you think through it, if at the highest level, if there are pay discrepancies that exist, say across gender or other demographics, and as employees move from job to job or from employer to employer, if the basis in whole or in any part of setting that new employee's salary is what they made at their last job, well, if they made something disparate than their equal worker, say a female who's paid less than a male for equal work at their previous job, basing their salary at the new employer on what they used to make in part, just sort of bakes in that discrepancy and perpetuates it. And that's really the issue that salary history bands are designed to deal with, which is to really remove the likelihood that some sort of past intentional pay discrepancy gets percolated through an employee's career. Let's go to the next slide, please. So there are many states that have salary history bands, and I think it's worth, we're going to show you several slides, and I'm not going to read all this to you, and you will get these slides tomorrow, if not sooner, for participating here. So don't feel like you've got to jot all these down, but these are some of several states that have some version of a salary history band, and they're not all the same. I think it's worth calling out a couple of different, a couple states here just to note some of the contrast. So if you look, for example, at Alabama there at the top, Alabama's salary history band really focuses just on whether you as an employer can refuse to hire somebody or interview them because they wouldn't tell you what their last salary was. So that's really, okay, you can't refuse to move forward with that candidate if they refuse to give you their salary history. But now look at Colorado. Colorado says you may not even ask about an applicant's history or rely on it in any way to determine their wages. So that's a much broader rule. Alabama says, okay, you can ask, you just can't take a negative action based on what answer you get. Colorado says you can't even ask the question. You can't even ask the question. Let's go to the next slide. Here's another set of states that have salary history bans. So let's perhaps contrast a few more. Look at Maine at the top. Employers may not seek information about pay history until after a job has been offered. Okay, so they can ask, but they can't base an offer on whether they've gotten the information about salary history. All right. So now let's look at closer to the bottom, New York. Employers can't seek pay history, but if they are given the pay history, they can call or go confirm the history if it's used as a basis to ask for a higher salary, right? That's a whole other level of nuance. And so, for those of you who work for multi-state employers, coming up with a talent and recruitment strategy or singular process might be difficult if you are looking to attract, retain talent across multiple jurisdictions, and appreciating these nuances and thinking through how to design processes that would comply with varying standards can be a challenge. I'll call out also just briefly North Carolina there at the bottom. We do not have a private employer salary history ban law, but we do have one for state agencies that says state agencies cannot request or rely on salary history when they're setting pay. Let's go to the next slide. Here's another set. And I won't repeat all of these to you, but I would just continue to call out and just note for you that there are significant distinctions within these. Michigan and Wisconsin, for example, down at the bottom, they have prohibited salary history bans. It's gone the other direction. And so on top of all this, these are only the states that we've listed for you. We've shown you 3 slides worth of states, so it's a lot, but it doesn't include municipalities, local governments, county and city governments that have salary history bans, which are always evolving. We track this pretty closely, and every couple of weeks, it seems, we've got a new one to add to our list of jurisdictions that have put out some sort of salary history ban. And so this is probably the primary issue that caused us to say at the top of this discussion, what we're telling you today is current now, but may not be current for very long, because this is a rapidly evolving issue. So moving now from salary history bans into a related issue, which is pay transparency. Erin?
Thanks, Brian. Yeah, so we have salary history bans, which say that employers can't ask about pay history in certain circumstances. And then we move into pay transparency laws, which generally say, but employers have to tell applicants what they're going to pay. So it's sort of a different side of the coin here. And pay transparency laws are right now being enacted by state and local governments. They're requiring affirmative disclosure of pay ranges by employers. In some states, it's an affirmative disclosure in all job postings. In other states, it's required upon request of an applicant, or it's required after an interview or after a job offer is given. Some states also require disclosure to current employees. So a current employee may want to know, the position I'm in, what is the range of salaries in this position? Or they may be looking to change roles and transfer into another role. And so some states require disclosure of the pay ranges for those new roles. Pay transparency laws are just another law under the pay equity umbrella. It's aimed at remedying longstanding pay inequities with the idea that transparency will promote more fair pay. And there are studies that are finding that transparency is affecting recruitment and retention. So I'm sure everyone has heard of the Great Resignation. Some employers are finding that it's difficult to attract and retain quality talent pools of employees. And so some studies are finding that increased transparency leads to increased employee trust in the company, which leads to increased productivity, engagement, and ultimately retention. There was a 2021 Indeed survey that I found that I thought had some pretty interesting statistics. It found that 82% of workers who responded to the survey feel more engaged with and fulfilled by their work when they're paid fairly or when they feel they're paid fairly. 81% said they're more productive and more loyal, less likely to leave. Job seekers and job applicants responded that they're 68% more likely to apply for a position that lists pay as compared to a posting that does not list the pay, or at least the pay range. And job seekers are 75% more likely to apply for a job if the company has developed for itself a reputation of paying fairly. And in many cases, that can start with transparency. So here are some examples of where pay transparency laws have been enacted or are effective. California was the first. It had a pay transparency law effective in 2018. Washington followed in 2019, Maryland in 2020. Colorado, Connecticut, and Nevada all had laws go into effect back in 2021. New York City is coming up a couple months, May 15th, 2022. Its pay transparency law will be effective. And Rhode Island is giving employers a little bit more time to prepare. They have passed the law, it is enacted, but it is not effective until January 1st, 2023. And just like with the salary history bands, this list is not all inclusive. There are more municipalities, local governments, cities that have pay transparency laws, such as Cincinnati, Ohio, but here I've just listed the big ones. There's also bills under consideration in many states, including Massachusetts, New York State, so not just New York City, and South Carolina. So we are going to take a little bit of a closer look at Colorado, because so far, Colorado has the most sort of comprehensive, or perhaps the most burdensome, pay transparency law for employers. And just like we said at the beginning, as a disclaimer, this is pretty general information. This is basic. This is not comprehensive. There are nuanced, really granular rules in Colorado's law that can make compliance a little bit tricky. And so these rules apply to job postings. These rules apply to promotional opportunities. There are rules for both. And so these slides are not legal advice for compliance. If you don't want to use these slides to comply with Colorado's law, because it won't be enough. There's definitely more you'll need to know to comply. But digging into Colorado, we have the Equal Pay for Equal Work Act. So this was effective January 1st, 2021. The pay transparency portion is found in Part 2, titled Transparency in Pay and Opportunities for Promotion and Advancement. It applies to employers that employ at least one person in Colorado. And it applies to job postings for positions tied to Colorado locations or remote work performable anywhere, and all promotional opportunities. And with the remote work, if you post a remote position and you have one employee in Colorado, at least one employee, even if you say it's not open to Colorado applicants, because it's remote, it's still covered by the law. And so Colorado, revised its compliance guidelines and sort of noted, hey, employers, we can't just say it's not available to Colorado applicants. If it's a remote position, it could be performed anywhere. It could be performed in Colorado. You already have an employee here, and so it's covered. In these job postings, employers are required to provide compensation and benefits information. So you have to include the rate of compensation or a range. It could be salary, it could be hourly, it could be if it's a piece or day rate compensation. It's got to include the compensation. Has to include a general description of any bonuses, commissions, or other compensation opportunities. and a general description of all benefits that the employer is offering for this position. Now, this rate of compensation, we understand that it can be hard to say, oh, this is definitely the range for this position. So Colorado has said, well, it just has to be a good faith range. So it's the range that you actually expect to pay. But if you end up paying a little more or a little less in the end, you still complied if you posted the good faith range. So, for example, you might have a position where you think, okay, this position's range is $55,000 to $75,000, but you have a really stellar applicant come in. They have extra certifications, they have higher degree levels, they have more experience than you were asking for. You can end up paying them more. Right? You're not stuck. You're not glued to this range that you posted, as long as what you posted was what you reasonably expected or actually expected to pay when it was posted. Additionally, it can be brief in the posting. So, you don't have to list out your entire employee benefit policies. You don't have to post a list of every single term and condition of your benefits. It just has to include the pay or range and a general description of the benefits. So saying $50,000 to $50,000, health insurance and IRA would be enough to satisfy the job posting requirement. Colorado has some more requirements for promotional opportunities. So besides job postings, they also take a look at any opportunities for promotion. And employers have to make reasonable efforts to announce, post, or otherwise make known all promotional opportunities to all current employees in Colorado on the same time or on the same day at the same time and before they've made a promotion decision. So a promotional opportunity exists when an employer has or anticipates a vacancy in either an existing or a new position. And it's a vacancy that could be considered a promotion for one or more employee in terms of compensation, benefits, status, duties, access to further advancement. So essentially, any vacancy in a new or existing position that is not the absolute lowest sort of tier of position within the company is probably a promotional opportunity to someone. This notice should be made in writing by a method that reaches all employees in Colorado, to all employees in Colorado for whom it may be a promotion, and sufficiently in advance of the promotion decision that employees receiving the notice could apply. So this is sort of another area where the rules get really nuanced and really granular. There's special rules for content and timing. For example, sufficiently advanced or this reasonable time amount. You can't post a position and leave it up for 30 seconds and then take it down, because that's not sufficiently in advance for the employees to really receive the notice. Or you could post these opportunities in a central location. You might have an intranet sort of posting board where you can post these and make sure that employees are aware that it exists and know where they can find it. And that would comply as long as you meet all of these requirements. And so there are a lot of special little rules to pay attention to here. There are exceptions. So this promotional opportunity notification requirement can seem really, really burdensome, especially in certain circumstances. And so there are some exceptions that may address some of those concerns. For example, one exception is promotions to replace current employees who are unaware that they're going to be terminated. And this is sort of a really practical consideration, especially with confidentiality. If you have an employee who is going to be separated from the company and they don't know yet, posting their position may give them a clue. So that could cause some sort of internal disruption. And so the law provides an exception for these promotional opportunities if someone's going to be separated and doesn't know it yet. There's also an exception for automatic consideration for promotion within 1 year. So say you hire people and in their employment offer or their employment agreement, it's in writing that, if you satisfy X, Y, and Z requirements, you will be eligible automatically for a promotion to this next tier position within the year. That's accepted. You don't have to notify Colorado employees of those promotional opportunities. There's exceptions for temporary, acting, or interim positions. So positions that last up to 6 months long, essentially, you don't have to provide notice of these opportunities. And then you also don't have to provide notice of promotional opportunities to employees outside Colorado. And this one gets a little bit tricky. Like, you have to notify your Colorado employees of promotional opportunities that may exist outside Colorado that they may be eligible for, but you don't have to notify employees outside Colorado. So this is one of those considerations of, if you are looking to comply with this law, do you want to provide notice to all your employees and have sort of a central job posting site, or do you want to set up some sort of system to provide notice just to your Colorado employees, especially if you only have one office or one employee in Colorado? So that's a consideration as well. Next, we're going to talk a bit about pay equity audits and sort of how to put all of this together as you're looking at your company. And Bryan is going to jump in here.
Thanks, Erin. So we talked a little bit earlier about pay equity audits as they are, when they are required by the OFCCP for federal contractors. In that setting, if you're a federal contractor, you're required to do these audits. Now, of course, the goal of that is one of the directives and purposes of the OFCCP regulations is to ensure as equal a workplace as possible in those workplaces that are federal contractor workplaces. And so in that setting, that's why pay equity audits are not just encouraged, they're required. But now we're going to talk about pay equity audits as they relate to everybody else. Because just because you're a federal just because you're not a federal contractor doesn't mean you ought not consider a pay equity audit. So let's talk about what they are and why you might want to do them. So the goal really is to, and I think about this often in terms of a bottom-up versus a top-down vantage point, which I'll come back to in just a second. But the purposes of doing a pay equity audit would be to identify differences in compensation that aren't the result of job-related factors and to remediate those discrepancies. And of course, relatedly, to get ahead of increasing pay equity litigation and laws that are designed to address pay equity issues. So what do I mean by that? And so going back to this concept of a bottom-up versus a top-down way of thinking about this. Of course, each employee is hired one at a time or a couple at a time, and compensation decisions and adjustments are made one at a time and over a period of time. And you may well be doing them with a 30,000-foot view of how a particular range of pay for a given employee fits within how you're paying for that position or that type of work generally, but maybe not. Of course, at a minimum, pay decisions get made just on a very discrete data point by data point basis. And so when you think about pay that way and you make pay decisions that way, you may or may not, those are all sort of proverbial trees, and you may lose sight of the proverbial forest of what does my pay look like across my employee population and across the demographics of those employees. So that's really what a pay equity audit would be designed to do, is to take you out of that tree level view and have a look at the forest. Let's go to the next slide. So if you were going to do this, how might you do it? I think the very first step would be to engage counsel, to talk with your lawyers about undertaking a pay equity audit for a couple of reasons. I mean, among the reasons you might consider a pay equity audit is to assess if you have any potential legal risk, because if you happen to determine that there are some pay equity disparities as a result of this work, that might in turn lead you to believe that there are some potential legal risks that you need to think through. And so the very first step ought to be to engage legal counsel who can help sort of design and craft and oversee and direct a pay equity audit for you. And in doing so, you would, one of the additional benefits of engaging counsel out of the gate would be to try to keep the work that you do confidential and subject to the attorney-client privilege. The next step might be, of course, to sort of design as a practical matter. Well, what are we looking at here? Are we going to look company-wide? Are we going to look in just certain functions? Are we going to look at just certain levels? Should we chunk that out over time? How do we think about that? And of course, you know, don't let my advice would be, don't let perfection be the enemy of the good there. Don't let the size of the potential project push you into a point of paralysis by not and prevent you from taking off the first chunk, wherever you think the first chunk most appropriately is. And then, of course, defining the purpose and scope of the project was really just who's got to be involved. What are we trying to accomplish here? Are we trying to reset pay? Are we trying to just make sure that pay levels are where we thought we were? Now, I will tell you too, and this is a nice loop back into what Erin was talking about earlier with the Colorado law. The Colorado pay transparency law has led to a lot of brand new visibility for employees as to compensation levels in their company, particularly those employers that are cross jurisdictional, meaning they have employees in Colorado and North Carolina and many other states. I can think of a recent example with a client who had an employee come and say, look, I'm in a position that looks a lot like the position that we just posted as a job posting. And because we have employees in Colorado, I know what you're offering in pay for that job posting. And I also know that that's not particularly in line with what my current compensation is. And so that triggers a couple things. First, that triggers a discrete review of, well, is there anything that we at least need to respond to that issue and analyze whether or not we have a discrete pay equity issue as between this role and employee and the one that we posted for. But those pay transparency laws, like the Colorado law, are more likely than not to give increased visibility to your current employees about what you're offering out in the market, which could in turn lead to the very types of reports of concerns that I just shared. So the point being that pay transparency laws are sort of a natural first domino that might cause more pay equity thinking and review processes to be appropriate for your company. Let's go to the next slide. The last thing that we wanted to talk about with regards to pay equity audits is really the details that might be involved, right? I mean, you've got to, what you're really trying to accomplish is figure out what are our goals for our pay and what are our policies about pay, and then are those policies and goals being effectuated in the devil of the details that is the pay data for our employee population. And so we've just listed here the types of information that would be most relevant, because of course, at the end of the day, what you're trying to figure out is, am I compensating people in an apples to apples sort of way? Equal pay for equal work, regardless of protected class or related immutable sort of characteristics of an employee. So that would be the detailed granular data that you would want to gather. And I've seen pay equity audits done sort of at the direction of counsel. I've seen them done in close partnership with counsel. I've seen them done sort of with three parties involved, perhaps a lawyer, whether they're an in-house lawyer or an outside lawyer, who then engages perhaps a pay equity consultant or some sort of HR consultant who can help you do this work if it's not something you feel like you've got the resources to do yourself. And so there's different ways to structure pay equity audits if you choose to do that. Next slide. All right, so I think I've covered a lot of this, and I don't want to particularly belabor the point, but obviously I would just say the upshot of all the pay equity work you do may be, we're doing good, we look pretty good, but it may be something less than that. And so focusing here on numbers 3 and 4, you know, at the end of the day, once you've done all the initial analysis, you've got to step back and say, what do we make of this? What are we learning here? And I think partnering with counsel can help you get a sense of, you know, how much of this is significant in terms of this really is an equity issue, or how much of it is just Are pay differences driven by factors that are appropriate because they relate to job performance, or they relate to tenure, or they relate to qualifications, or other things that are appropriate variables? So just remember that just because at first blush you might notice that it looks like you've got some disparity, it may be that disparity is justified, and it may not. Just it's going to depend on the specific facts. Next slide. Okay, so we have shared a lot of information with you from a lot of places, a lot of topics from a lot of states. And so if you have questions, we're most happy to entertain them and try to answer them as best we can. Please feel free to put those in the chat box. And I realized one other thing I should have said at the top of our time together is that, of course, SHRM credit is being offered for our time together today, and that code will be available here in just a few minutes.
If anyone does have questions and just, can't think of how to word it now in the chat, always feel free to reach out to one of our labor and employment attorneys after the presentation or after you receive the materials tomorrow. Looks like we have one question in the chat.
Any recommendations for a PEO in North Carolina to help with outsourcing some of this need? I want to make sure I'm construing that correctly. I'm going to assume that that's a question designed to ask if a PEO is looking to be a service provider or is looking to get a service provider to help do some of this work. Any recommendations for that? I think there are several. Again, I would probably start with counsel. I think that's got to be the threshold, just as a best practice. And the reason I say that is if you go direct to a third party, HR service provider or consulting firm that does this work, what you're not doing is working through counsel. And in doing that, you are not having that work directed in a way that's going to preserve attorney-client privilege. So I think a first step is to think through. I'm not suggesting that you absolutely must work through counsel or seek to cloak the work that you're going to do in attorney-client privilege, but I do think that's a best practice. So I think you ought to think through first, is that something that we want to make sure we try to do? If so, I think starting with counsel is the right way to go. If not, then I think going direct to some of the very good HR consulting firms we have around our state is a great next step.
Thank you for attending today's presentation. We will now end the webinar.